Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News. Happy Saturday morning. Well, I've got your morning cartoons for you. You know those cartoons where they have the oversized bump on the head after they drop the anvil, the Roadrunner style? Well, I guess we have that with Jane Doe here. We have an oversized belly, but no pregnancy. Clayton Echard's lawyer calls out faux baby bump in new court documents. We received several new motions. I got to be honest with you. I'm going to tell you right now, this is a bowl of soup. This isn't a main course video. The motions don't reveal any of the jaw-dropping emails we've already seen. But if you do enjoy seeing a lawyer exercise their right to cut deep within the court documents, then boy, I'm going to need to ask for Isabel over at Woodnick Law to get a raise. Next time you're negotiating your raise, play this video. You know what I mean? Come on. She's doing a great job. Follow me on Instagram at DNeals, patreon.com/Dave Neal for behind the scenes bonus content, and also Bachelor Rush Hour, the hit podcast. Now, I'm actually going to tell you guys this. I'm going to share with you two different court documents. Actually, no, three. One of which is Jane Doe's lawyer now getting exiting. We're going to show those documents. They don't really reveal much. And then we'll show the other motions in the oceans. Now, if you want more content today, I've got my full interview up with winner of Greek Bachelors, Athena Voss. Here is a quick clip of that interview. It's on Dave Neal Show and Bachelor Rush Hour. I got to tell you, it's fascinating. Have a watch. Clip, which was insane. Having only watched the American version, the finals, you're in Santorini, I believe, at a pool overlooking the beautiful views, and he chooses you over the other lady, but he picks in front of you two?
I know! I felt so bad.
There it is. The moments.
Oh my God! I love you with all my heart.
He's literally proposing to you over the other lady right next to each other. Does she just walk away? Like, he basically just chooses you. You kind of fall to the ground. I thought you were going to fall in the pool. And then I'm like, honey, you got to watch this. This is crazy.
To be honest, I forgot she was there.
All right, there it is, folks. That full interview is up on Dave Neal's Show and on the audio only on Bachelor Rush Hour. Let's dive right into today's stories. So the first motion in the ocean of the Clayton Echard paternity scandal is the motion to withdraw as counsel for petitioner with client consent. What this means is this is the paperwork needed for Jane Doe's lawyer to be like, I'm out. Good luck. I'll see you later. I've actually got taxes I need to do and other fun things I'd rather be doing than this right now. Pursuant to Rule 9D of the Arizona Rules of Family Law Procedure, Lexi Lindvall, beautiful name. You can only be two things, a lawyer or a porn star with that name. I mean, those are great names. And the attorneys of modern law hereby request to withdraw as counsel of record for petitioner Janeth Doe. If undersigned can no longer continue with the representation. Petitioner agrees that the firm discontinue representation as evidenced by her signature on the attached consent. So if Jane Doe didn't give consent, then the lawyer would have to provide a reason to why they wanted to exit. So what my guess is happened, maybe this is fan fiction, I don't know, you tell me, is that Lexi Lindvall was like, look, all of this stuff you're doing, it's too much. Noticing that there is a lot that is working against us, and I don't have the time and don't think we can win this case. I did my part, I cashed my check, and I'll catch you on the flip side. And then, of course, Jane Doe says, no, I can't, you can't do this. And she goes, well, please let me go in peace. Let's do this amicably. Otherwise, I will share the truth. Again, that's my opinion of what might have gone down. And then, of course, we have the signatures down there. So that's the first part. And also, in other non-motion news, we're noticing videos are now unavailable. Does that mean we need the X-Files music? That's right, folks. Videos have disappeared in the world of Clayton Echard. That's right. One of the court documents, court cases, is gone. The November 2nd hearing video removed from YouTube. So it's been reposted, I think, on Vimeo or whatever. These things live on forever, right? Everyone's got a copy of it. It'll bounce back. Now, of course, this is why I don't just post random court cases. I do what's called fair use, where I'll share a court issue, but then I'll also talk about it just to protect myself, to show that I'm adding value to it. You might not think this is valuable, but some might. In which case, that's what the fair use is all about. Okay. This is 18 pages. We're going to fly through it because some of the pages are redundant. No, this is what I've learned in the law room here is that there's a lot of redundancy. You know what I mean? Every single motion has to have all the evidences attached and this and that, the exhibits, and therefore there's going to be things we already covered. This is a motion for sanctions pursuant to Rule 26, and this is information that just came out, so this is breaking, brand new to us. Respondent Clayton Echard, by and through undersigned counsel and pursuant to Rule 26, Arizona Rules of Family Law Procedure, hereby filed his motion for sanctions against petitioner Janeth Adoeth for filing her petition to establish paternity. Petitioner Jane Doe filed the underlying actions for an improper purpose without medical evidence to support her claim that she was pregnant and or that she was pregnant by respondent. Petitioner Jane Doe could not have become pregnant from the limited encounter the parties had and therefore premised this entire action on a fiction. Petitioner violated Rule 26 in her petition and subsequent filings. Here's the argument they make. This matter arises from the establishment petition filed August 1st. Also pending before the court are respondents' motions for leave to amend respondents' response to petition to establish paternity, respondents' expedited motion to extend dismissal date on inactive calendar, and schedule an evidentiary hearing, respondents' notice of filing affidavit of non-paternity. So these are all the things, most of which we've already covered. Rule 26B provides as relevant here that by signing a pleading, motion, or other document, the attorney or party certifies to the best of the person's knowledge, information, and belief formed after reasonable inquiry. It is not being presented for any improper purpose, such as to harass the claims, defenses, and other legal contentions are warranted by existing law. The factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Rule 26 provides if a pleading, motion, or other document is signed in violation of this rule, the court, on motion or on its own, may impose on the person who signed it, a represented party, or both an appropriate sanction, which may include an order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including a reasonable attorney fee. So here's my thought of what's being said here. Because they violated why they brought this, court to trial, right? But why they, violated by the improper reasons that they did, we think that's reason alone for them to pay the attorney's fees. I don't have the power to give Isabel a raise, but if I did, I would say Jane Doe should cover the raise for Isabel. Can we do that? Can I issue a bonus? Can you put this in the court documents? Well, Dave Neal says that she should get paid double her rate here for all of the good work she's doing. I don't know if I have that jurisdiction. But as far as the court of public opinion goes, I think we can agree in the comment section that I grant this court. Leave a comment. Can we grant this? Aye. Anyone in the comment section, do you grant this bonus for Isabel here? Never met Isabel, but she seems lovely. I would like her on my side, if ever in a god-awful, knock on wood, fake paternity scandal. The requirements of Rule 9C have been met and a good faith consultation certificate is attached hereto. See also respondent's motion for leave to amend respondent's response to petition to establish paternity. Put that on a mug. Respondent's response objection to petitioner's motion to dismiss petition to establish paternity. Legal decision-making, parenting time, and child support with prejudice. Rule 26 sanctions are appropriate and warranted. Petitioner's behavior, Janeth Doe, is the exact type of conduct. I think I should be doing this with like the Law and Order music. Hold on, let's get to the good stuff here. Petitioner's behavior is the exact type of conduct that Rule 26 is intended to sanction. Petitioner was never pregnant by respondent and filed this underlying action in bad faith and with the sole intent of coercing respondent into having a relationship with her. Petitioner's commencement of this action in original filing was made for an improper purpose under Rule 26B. And of course, some of that evidence off the top of my head would be the contract she wanted Clayton to sign to date her before going to the press and all of this, knowing there's no fetal DNA, there was never a pregnancy, blah, 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 blah. Petitioner instigated this action when she filed for her petition to establish paternity. Legal decision-making, parenting time, and child support on August 1st, which alleges she had sexual intercourse with a respondent, became pregnant by him and requested this court enter orders for joint legal decision-making, a parenting plan, and order respondent to pay her child support. Petitioner's petition to establish was filed for an improper purpose because petitioner was never pregnant by respondent and could not have become could have not have become pregnant based on their one encounter of oral sex on May 20th, 2023. Despite no underlying orders, petitioner filed a motion to communicate on August 8th, 2023, and motion to compel. By the way, swallow that, justice, folks. This court denies both motions. Respondent filed a response on August 21st, denying that petitioner could be pregnant by respondent after one incident of oral sex on May 20th, 2023. When petitioner did not get what she wanted, including attempting to get respondent to enter into a dating contract, she went to the media, Reddit, The Sun, People Mag, Page 6, Medium.com, the police, respondent's father, and even threatened self-harm. See respondent's response objection to petitioner's motion to dismiss. When the media turned on petitioner and had doubts about the veracity of her pregnancy, as no verifiable medical evidence existed, petitioner obtained an order of protection against respondent based on cyberbullying. She also tried to get an order of protection against me. It was denied because in the country I live in, we've got First Amendment rights. Can't do that. Still suing me for harassment, though. We'll see how that goes. February 8th, 2024. Respondent obtained an injunction of harassment against petitioner. That's Clayton got one against her based on the receipt of 500 harassing messages. Can we get Jane Doe to get like a T-Mobile or like a Mint Mobile sponsorship? Are you harassing somebody? And do you not want to pay for those text messages? Get unlimited text messages with Mint Mobile. During the proceedings on November 2nd, 2023, petitioner wore a fake stomach, a moon bump they're calling it, to appear pregnant, and claimed with no scientific support that she was 24 weeks pregnant with respondent's twins and due on the good Lord's day of lovemaking, February 14th, 2024. The old Cupid's babies. That, you know, the Cupid Shuffle. 2 hops this time. Is that the song? Cupid Shuffle? No, different one. Anyway. Petitioner then sought to have this court enter orders against respondent despite no verifiable proof petitioner was pregnant and no child support to this court's jurisdiction. With respect to entering parenting-related orders by filing an application and affidavit for entry of default. All of this means she did this to F with Clayton. It's all bullshit. Can I sum this up and just say, Honor, I could read you these 18 pages, but let's just call it what it is. Bullshit. Despite merde galore, as the French say, full of you know what, je ne sais quoi. Despite providing no verifiable medical... Am I losing my mind today? The coffee's hitting strong. Despite I've got coffee. I've got 100% coffee DNA. 3 tests have proved it. Despite providing no verifiable medical evidence that she was pregnant or that she was pregnant by him, only positive HCG tests and fabricated sonograms, petitioner sought to force respondent to communicate with her and threaten to go to the media if he did not comply. I tell you what, I'm suing all of you guys if you don't leave a nice comment, give this a like, and also go find my podcast and hit subscribe. Can I do that? I just did. It's my law, bitch. The respondent was The Bachelor on ABC, and the petitioner knows it would be in his best interest to keep the details of this case out of the public eye. Also, in her motion to compel, petitioner admitted she had requested a 1 to 2 week trial relationship prior to filing her underlying petition and asked this court to hold respondent in contempt of court for not talking to her. You need to talk to me. I feel like she would do that in when she was like 8 years old at her birthday party. Her mom would just start suing people. You didn't get her a good gift. You didn't talk to her. You didn't come to her. You didn't RSVP for her birthday party. Sue her. Petitioner's own words prove that she instigated this entire action, including fabricating a pregnancy, to coerce respondent into talking and dating to her. Yeah, cough here. Petitioner's motion to dismiss is unsupported by existing law under Rule 26B. Jurisdiction was established at the time of petitioner's initial filing, which petitioner continued to avail herself of through each additional filing made in the court of this matter. Ostensibly, fearing that she would be held accountable for her disturbing and unsettling behavior, petitioner recently filed a contested motion to dismiss on December 28th, the entire action alleging lack of subject matter jurisdiction. As discussed more fully in the response to that motion, Arizona law is crystal clear that jurisdiction attaches at the time the action action is filed. Subsequent events or acts by the parties cannot deprive the court of jurisdiction once attached, even if those events would have defeated jurisdiction if occurring before the action was filed. Petitioner claimed at the time of filing that she was pregnant with respondent's children at the time of filing, so that fact that she is not currently pregnant does not deprive the court of jurisdiction. Statutory jurisdiction does not automatically divest unless the statutes expressly state whether and to what extent divestiture occurs. Title 25 contains no such provisions, in the Fry case cited in respondent's January 3rd response to the motion to dismiss is highly analogous to the current circumstances. All right, so it goes on and on and on. Petitioner's factual contentions are not supported by evidence and did not become supported by evidence after investigation and discovery. The petition lacks evidentiary support beyond petitioner's assertions. So, okay, it goes on and on. We get it. At least 2 fetal DNA tests have come back with little to no fetal DNA. She's still arguing this point with reality, Steve, by the way. She's still saying, I drank too much water that day. I don't know. The Monster Energy killed the results. You know what I mean? I don't know. I don't know what she's saying, but she's arguing it. I don't know. It's like people like to believe science until it works against them. Petitioner carefully alleges in her motion to dismiss that she is no longer pregnant. You know what? I would almost, if she really wants to claim that the tests are faulty, I'd love to see Ravgen sue her to be like, all right, here's the results. Here's everything that, because at some point, isn't she kind of defaming Ravgen in a certain way? Hey, I ain't no lawyer. I'm not no Isabel there. You know what I mean? But, pursuant to my opinion, can you imagine fighting with your partner? Well, pursuant to my opinion, I left the toilet seat up because hereto I was prepared for going back in, to the bathroom before you. So in order to dissuade okay, you get the point. All right, this court may investigate and impose sanctions on its own motion. It goes on. In conclusion, pursuant to the above and consistent with Rule 26, this court should impose appropriate sanctions against petitioner, including but not limited to awarding respondent his reasonable attorney's fees and costs incurred. I hope those reasonable fees cover a nice daiquiri for one, Isabel and Greg. I've been giving Isabel all the credit here, but of course Greg is the head honcho, the boss man, Woodnick, that is. He is the sort of steam in the engine known as the Woodnick law firm. Okay, the beat goes on, and then Clayton signs it. And that's only page 9. And then we have good faith consultation certificates. I'm going to slowly go through this. I don't really know what this means. And then here we have the text messages that we already showed, which was Clayton trying to meet up in a public space because he was afraid. And then we also have some other things here, which would be some of the initial filings they're using as evidence. This is from Janeth Doeth. She said on June 1st, Clayton has sent threatening messages since discovering I was pregnant, such as, I legitimately hate you right now. Listen, hating somebody is not threatening. Hey, guess what? I hate asparagus. Dave Neal is threatening asparagus. Get him. He's a veggie hater. Actually, like asparagus. The thing is, you got to cook it in butter and do it right. Don't steam that shit. Saute it like a man. He said, I legitimately hate you right now. My hatred will only grow if you decide to put me through all of this. My animosity would last for a lifetime. Clayton's like the opposite. He's like the opposite of a love letter. My animosity would last for a lifetime. My hatred knows no bounds when it comes to you, and that's something either of us want to subject ourselves to. One thing about me is when I make up my mind for good, especially when it's rooted in anger, I don't sway. We should get some Clayton merch shirts that say I don't sway. Even my hate is toward you and you only. If you decide to not take plan B, and in the wild event that you are pregnant, I would hate you even more. Clayton Echard was the Bachelor and has many diehard loyal fans. This, of course, was from September 21st, which is what, autumnal equinox? Is that what it is? He and I are involved in a very public paternity case that is being covered by every major media outlet. Not really. Clayton posted to a story to his 270,000 followers to look me up, which they have, and I've been sent threatening and harassing messages by his followers. I explained this to him and asked him to take down the post, which he did not. By posting personal and sensitive information about me publicly and without my consent, he has made me feel humiliated and embarrassed. Let me ask you this, Jane Doe. Do you feel humiliated and embarrassed from what you shared publicly without his consent? Don't let karma bite you in the ass. So then she goes on and claims that some of these users on Reddit are Clayton, which we know are not. As she said, he has posted private and confidential information, including facts about my medical history that is only known to him because of our paternity case. That is why it is 100% traceable back to him. So anyway, they did this whole... She talks about a prior abusive relationship which inspired her TEDx talk, which, mind you, a TEDx talk, not a TED talk. A TED talk is done in front of a live audience. A TEDx talk, you pretty much buy your way into. I'm not saying she bought her way into it. I'm just saying, I'm essentially doing a TEDx talk right now. Yeah, it's not on my resume, not on my LinkedIn, folks. As a result of what he posted, I've gotten harassing messages that have told me to harm myself. Listen, as a result of what he posted, crazy strangers online did this. That's not an extent. Like if someone watches my video and does something crazy, I'm not asking them to do that crazy stuff. In fact, I'm saying the opposite. Don't contact her. Don't do any of that. Don't say her name in the comment section. Like she's virtually invisible to us. This is about justice for Clayton. But of course, in finding the justice for him, this has to be exposed. Dirty laundry, folks. On October 6th, she said, when combined, all of this has led me to feel extreme anxiety and fear for my safety. I've not left my house since September 28th. So she says she's not leaving her house. Okay. So we know there you go. Maybe she's getting Postmates. She's Postmating her ultrasound appointments. I'm not really sure. So it goes on. And then they've got other, the minutes that were taken, sharing the exhibits and all that. I'm going to see if there's anything worth sharing here. It is ordered denying. So on October 25th, here, these minutes might be the first we've seen them. It is ordered denying plaintiff's motion requesting that the hearing be closed from the public or that this hearing be closed from watching online, filed October 25th, and denying plaintiff's motion requesting she attend virtually or telephonically for hearing scheduled October 25th. So she tried to get this sealed from the public because she's trying to do two different things. She's trying to destroy Clayton and also not have the audience be able to poke holes at it. When I don't know, was this the court case where she had the fake baby bump? I'm not sure. The court finds by a preponderance of the evidence that there is reasonable cause to believe. Okay, so this is where it gets crazy. This is, I believe, the court case where, I could be wrong. I think this is where the court gets an order of protection. So I think they had a temporary order against Clayton, and this is where they do an official order of protection against Clayton. This is wild. The court finds by a preponderance of the evidence that there is reasonable cause to believe that defendant has committed an act of domestic violence within the year. So the court's saying there's enough evidence to show. And it's like, well, what evidence? I don't know if this is true, but I've heard that judges, if they deny restraining orders, can be held liable if something horrible happens. So out of a preponderance of caution, did I say that right? They will rule in favor of the person pursuing the restraining order against the other person. The only problem here is that she wins the restraining order and then she goes to people and says, how could you not take my side? I have a restraining order against him. And then once you see how easily she got the restraining order, it starts to make you wonder if the system's exactly, equal here. And I don't think it is. I think in most cases, people that seek restraining orders need them for a reason. I just know in the future when I hear someone has a restraining order against someone else, I'm just going to say, I'd like to see the court papers, please. I'd like a preponderance of evidence, please. The court further finds that good cause exists to continue the order of protection. And I'm sure Clayton doesn't care in the sense that he's like, good, I don't want to be near her anyway. He's not the one contacting her. He's not the one doing any of this. But, of course, we know getting an order of protection can mean you're stripped of certain amended rights, like the right to bear arms. It is ordered that the order of protection issued at Superior Court on October 6th shall remain in full force and effect. Let the record further reflect that the parties receive a copy of the aforementioned documents in open court. Let the record further reflect that plaintiffs Exhibit 2 through 10, 12 through 18, and defendants Exhibits 19 through 33 and 36 through 50 are disposed. Now, I've got it on record from my source, not on record, a source told me this, that Clayton, she was basically saying he shared the photo of her in a bra and belly bump. She also accused me of sharing that, and I did from neck down, but she called that revenge porn. What? Revenge porn. She's got photos in bikinis. She shared that same photo to her public Dropbox and all these other things, which she shared publicly with Reddit and all of that. So, no, I'm not the one who leaked this, and Clayton isn't the one who leaked it. You did, Janie. You leaked that yourself, and it bit you in the ass. And for some crazy reason, even though you leaked it, you got a restraining order against him. Banana Alanda. So it goes on and on and on. You can pause there. And I think we have finally, here's 10 pages. I'm not going to read it all. Respondent's response objection to petitioner's expedited motion to quash deposition. This is Clayton saying, and let's just go to the conclusion here. This is Clayton saying, we don't want, they're objecting to her wanting the deposition to go away, which right now I believe is scheduled for January 17th. Are you free, Jane? Check your calendar. Do you have any upcoming podcast interviews in the way, or are you open? I think you're free, right? Rule 52. A deposition must be quashed under 52E where it fails to allow a reasonable time to comply, requires a person who is not a party to travel a far distance, requires disclosure of privileged information, or subjects a person to an undue burden. I'll tell you this. I'll pay for the Uber. I'll get you an Uber Black if you want. I'll get you an Uber Black or a pool, whichever you want. No one should join an Uber pool with her. You might end up pregnant afterward. You know what I mean? A deposition may be quashed under rule if it requires disclosure of trade secrets and unretained experts' opinions. So none of that. Not traveling too far. Petitioner failed to meet her burden of proving why she should not participate in the properly noticed deposition. So basically, the only reason they don't want to be deposed is they're saying, well, we've got a motion to dismiss. Let's see what the judge says first before we do this whole deposition thing. And of course Clayton side's like, no, we want to depose you. We want to be able to cross-examine you here. Petitioner alleges none of the above reasons in her motion to quash, other than claiming this court does not have subject matter jurisdiction over the matter. It does, as explained below and in depth in a respondent's response objection to petitioner's motion to dismiss. None of the mandatory or permissive considerations set forth. So that's Clayton's side saying you don't have enough reason to quash this. So knoweth quasheth, Janie doeth. She continued to perpetuate fraud upon the court by claiming under oath that she was 24 weeks pregnant and due on February 14th, despite 2 fetal DNA tests showing little to no fetal DNA. Petitioner even went as far as attempting to submit a fabricated sonogram into evidence. Petitioner claims that she was pregnant by a respondent. The court has subject matter, so it goes on and on and on. All the different rules as to why they should not quash the old thingy. Let's see if there's any exhibits we need here. No, that's just your standard exhibits where they're saying they're going to, take care of this in a timely fashion. All right. Well, if you want more content, you got Dave Neal's show. If you want to help me out, definitely, if you enjoy the coverage here and want to help me out, the best thing we can do is continue to push the Bachelor Rush Hour podcast up the charts. The best way to push it up the charts and get exposed to new people is to subscribe and leave a review. That'll get new people to see it, true crime people, anyone who can help bring more attention to this case. What do we want? The truth to rise to the top. It's doing just that. Have a great weekend, everybody. I'll talk to you later.